And with that, we are now perfectly ready to start. So welcome everybody, excited to have you in class today. My name is Carrie Sotner, I'm the Chief Learning Officer, and today I'm here at the National Constitution Center. And I'm so excited to talk about this topic. We get to talk about the 14th Amendment, why it was written, how it was written, and then the practice of using the 14th Amendment today connected to the Bill of Rights. I'm also excited about it because when I'm at the center, I get to walk through our Reconstruction exhibit that is all about the 14th Amendment. And the guy that helped build that exhibit, and it's going to teach us so much today, is with us today, Tom Donnelly. So Tom, welcome. Excited to have you. Tom's our top scholar at the National Constitution Center. Tom, how excited are you to talk about probably one of your favorite topics, right?
I'm always excited, but I'm even more excited today. This is like absolutely my favorite topic to talk about.
This is like...
I have to contain myself, so...
Okay, so people be ready for it. We're all going to talk fast and be super spazzy because that's how you should be when talking about the Constitution, overly excited and uncontainable. So Tom, we always frame our classes with the questions. So when we're talking about the 14th Amendment, we will start with the text and say, what does it say? And then what I love about the way you break this down, Tom, our students are going to really kind of dive into it. What are the big core principles, the big core values that are spelled out in those words that we hear? Because sometimes the text is really hard to understand, but then when you pull the big ideas out of it, we can spread them out. How did the 14th Amendment transform our country and our Constitution? And how does it promote ideas like equality and freedom, those big values? And then what's the ongoing debate? So a lot to get through. And again, students, all of these PowerPoints are online. And if you ever go online and check them out on the 14th Amendment page, you will see there's 8 million slides. So you can really have fun with these PowerPoints on your own and see what we didn't get to, because there's always that. So I'll kick you off, Tom, go through the big idea, and then we can go anywhere you want to after that.
Absolutely. So the big idea here is that the 14th Amendment wrote the Declaration of Independence's promise of freedom and equality into the Constitution. It really transformed our Constitution forever. And that's why many scholars refer to the 14th Amendment as a core part of our nation's second founding. So maybe, Kurt, let's begin with the text of the Constitution itself. And so here, in the end, Section 1 of the 14th Amendment, it's a big wall of text. But it's so important that I actually think it's worth reading in full and then digging into what big ideas you find in here. So here's the text. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So that's a real mouthful. A lot of it may seem legalistic and technical, but it really combines, I would say, 4 big ideas. So the first big idea in the 14th Amendment we see is the idea of birthright citizenship. That's that first sentence you see there, talking about citizens of the United States. And what this provision is saying is that Dred Scott v. Sanford was wrong. African Americans did have rights which the white man was bound to respect. And if you're born on American soil, you're a United States citizen. This sentence alone settles so many of the debates that happened over the Constitution before the Civil War. But that's not it. That's one, birthright citizenship. The second big idea, though, is equality. Now, it's easy to forget this, but the original Constitution, the 1787 Constitution, is silent on the Declaration of Independence's promise of equality. But with the Equal Protection Clause of the 14th Amendment, we write that promise into the Constitution. That's that last part you see there, nor deny to any person within its jurisdiction the equal protection of the laws. So that's birthright citizenship, equality. The next big idea is freedom. The original Bill of Rights was limited to abuses by the national government. You could only use the Bill of Rights to go after the national government if it violated your rights. Now, after the 14th Amendment, the Constitution also protects us from the abuse of rights by the states. So when a state violates your right to free speech at the governor, the state legislature, your right to religious liberty, your right to keep and bear arms, because of the 14th Amendment, the Bill of Rights now extends not just to the national government, but also to the state government. So that's birthright citizenship, equality, freedom. The last big idea we see in the 14th Amendment is found in Section 5 of the 14th Amendment. It's the idea that the national government has power over civil rights. So after the 14th Amendment, Congress now has the power to enforce all of these protections that we see in the 14th Amendment. The Reconstruction Amendments are the first set of constitutional amendments to expand the reach of national power rather than restrict it. So after the 14th Amendment, Congress has more power than it did before. Here's the powerful language, Section 5 of the 14th Amendment. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. So birthright citizenship, equality, freedom, and national power over civil rights.
Love how you break that down. And Tom was talking about the Dred Scott case, which I can send you the link to as well if you don't know that case. That was the one connected to birthright citizenship. But these big ideas, these big values that we hold so important, and it's kind of like mind-blowing that they're really not put into the Constitution until the what year is the 14th Amendment? 1868?
1868, it's ratified.
Yeah, so much later than you think about it. But one question as we dive into this, and I want to dive into, who wrote it, what was going on at that time period, what's connected to it. But it's really important that this Section 5 almost like shifts the power of the balance of power between the three branches of government. So why was it so important for the writing of this generation with the 14th Amendment to give Congress more power? Because technically, Congress is allowed to make appropriate legislation, but they almost like doubled down on it in the 14th Amendment and said, oh, no, you definitely have more power to do this work. So that's one of the additional questions to chime in. Do you want to start with the writer of the piece, or do you want to look at the other amendments around this time period and what was going on?
Well, let me first say something, just respond to what you just said there, Curry, which is so important to emphasize. That Section 5, it's not just about the separation of powers. So it's not just about Congress having more power versus the other two branches of government, but it also rebalances our system of federalism, that balance of power between the national government and the states. And so if you look at the 14th Amendment, the language we just read, what you see so many different times is that no state shall have the power to do X, Y, and Z. And so what the 14th Amendment is about in a lot of ways is it's about giving the national government the power to attack state abuses, and it's about giving Congress a key role in doing it. So it's not just leaving it to the courts, but it's also putting some key powers in Congress's hands.
And I love that. I love that idea that with this amendment, it now says the Bill of Rights is for everybody. It's not just the federal government that can't do things. It's saying people are protected and these Bill of Rights are yours and you're cloaked with them, or they're sticking to you as the individual. That's the extra power in that last. Sometimes we skip over that, not us, but sometimes people skip over Section 5 and it's just so darn important. Okay, now, do you want to dive into the time period, or you want to look at who was the writer of the 14th Amendment?
So let's first start with the author of the 14th Amendment. So it's one of my constitutional heroes, John Bingham. He was a U.S. House of Representative member from the great state of Ohio. So he had an amazing record, beyond writing the 14th Amendment, the Section 1 of the 14th Amendment. He was a leading anti-slavery voice in Congress before the Civil War. He was part of the team that prosecuted John Wilkes Booth's co-conspirators in the assassination of President Lincoln. He was a leading Republican in the House of Representatives after the Civil War during Reconstruction. He delivered the closing argument in Andrew Johnson's impeachment trial, and he became America's minister to Japan after he left Congress. USS Grant appointed him to that position. But for our purposes, the most important thing he ever did was he was the primary author of that text we read at the beginning of class, Section 1 of the 14th Amendment. Justice Hugo Black, who was one of the great justices in the 20th century, would later call John Bingham the 14th Amendment's James Madison. And that's the way to think of him. He's not as famous as James Madison, but his constitutional influence is astounding, and all Americans should know about it.
And I think that's such a good point. So students, we're going to charge you with that. We want to make John Bingham as important and well-known as, well, he is as important, but as well-known as James Madison. If we think about, like Tom said in the beginning of class, so under the law, the 14th Amendment is the one that's used the most. The author of that should be very, very well-known as well. So diving into this time period and kind of looking at this time period, it's not just the 14th Amendment. We've got a major changes going on in our country at this time. We're ending a civil war, and we have, what always feels like rapid fire, boom, 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 the 13th, 14th, and 15th Amendment. So do you want to put that into like place and space at that time, and then we'll dive into what leads us up to that moment?
So the 14th Amendment is ratified after the Civil War. in 1868. It's part of a series of 3 transformational amendments that many scholars refer to as our nation's second founding. It's the 13th Amendment, 14th Amendment, and 15th Amendment. These amendments were really about setting new constitutional baselines, new constitutional rules, a new constitutional foundation for post-Civil War America. And so the 13th Amendment abolishes slavery. The 14th Amendment, which we're addressing today, wrote the promises of freedom and equality into the Constitution. And the 15th Amendment banned racial discrimination in voting. And so really, if you're thinking about what is the key, what's the core purpose of these amendments? It's about eradicating the institution of slavery and putting African Americans in the equal citizenship, in a form of equality with all other Americans, ensuring that they are equal citizens. They have an equal commitment to citizenship, freedom, equality, and political rights. And so here, if we're looking at what is this period, the period is known as Reconstruction. It's this powerful period where we put these 3 core constitutional amendments into the Constitution. They transform the Constitution's text. And it's a brief period, but it's a powerful one. It's America's first attempt at really trying to get multiracial democracy right. And it worked. It actually worked for a very brief period. It worked. And so we had African Americans meeting in conventions, conversing with one another, and telling the rest of us what they thought was essential to creating equal citizenship after the Civil War. We had African Americans voting in massive numbers, electing Republicans throughout the South and helping to push for the ratification of the 14th and 15th Amendments. And we had African Americans holding office at all levels of government as US senators, US House members, governors, state legislators, all the way down to local positions like justices of the peace and sheriffs. And for a brief time, we even had a national government that was acting to protect the constitutional rights of all and attacking discrimination throughout the South among ex-Confederates. But what we know, Curry, is tragically, this Reconstruction, this project, it collapsed. It collapsed after a short period of time. And what we see is white Southerners taking back political control of the South and putting in place the system of Jim Crow and imposing second-class citizenship on African Americans. This was a combination of intimidation, violence, laws on the books that kept African Americans away from the polls, but also created an entire system of apartheid, especially in the Southern United States, where African Americans had to attend different schools, drink at different water fountains, stay in different hotels, eat in different restaurants, on and on and on.
And I thank you, Tom, for laying that out, that there's this like glimmer of hope, that there's this moment of experimentation and it's working. And the office holding is like almost 10,000 office holding positions from sheriff on to senator. It is unbelievable. And then, as you said it, even our national government was working and enforcing this. Everything was cooking and working together. And then the resistance begins. But I love that you named it apartheid, because that is something that probably a lot of our teachers listening remember, these stories about apartheid ending in South Africa. And then thinking about how does that play a part in our country during this time period, and that separation based on race. And students, if that's not a word that you're used to, it's a really interesting story of how we see that in our country and other countries. Tom, I'm going to ping to Plessy versus Ferguson that really sets up this system that separating things is okay in our country, that this idea at this time period that pulling people apart based on race is something that we're okay with as a country. We sanction as a country from our smallest laws to our national laws.
Absolutely. So 30 years before Plessy v. Ferguson, here's how John Bingham describes the purpose of the 14th Amendment. He said he sought a simple, strong, plain declaration that equal laws and equal and exact justice shall hereafter be secured within every state of the Union, guaranteeing equal protection for any person, no matter whence he comes, or how poor, how weak, how simple, no matter how friendless. Fast forward 3 decades, and we have in place the system of Jim Crow segregation in the South. And in the case of Plessy v. Ferguson in 1896, the Supreme Court, in a 7-1 decision, says that these Jim Crow laws are constitutional, that they don't violate the 14th Amendment. Now, Homer Plessy was an African-American in Louisiana, and he worked with a group called the Committee of Citizens who opposed Louisiana's 1890 Separate Car Act. So this is a law that required segregated railroad cars within the state, separating African-American from white passengers. And Plessy was chosen as a test case. In the end, the Supreme Court, though, again, in a 7-1 decision, said that this Louisiana law was constitutional, but we also remember the one. It wasn't unanimous. The majority opinion was written by Justice Henry Billings Brown, but there was a powerful dissent written by Justice John Marshall Harlan. So while the Supreme Court, the majority said this law in Louisiana, which separates African-American passengers from white passengers, it's a reasonable law. It's okay to separate people by race, that this is a normal exercise of the state's power to protect the health, safety, and welfare of their residents. John Marshall Harlan said, what in the world are you talking about, Supreme Court? What constitution are you reading? What can be clearer about this law than that it brands African Americans with a feeling of inferiority, that it places the force of the law in a way that separates the races and ensures inequality for African Americans. Here's the powerful language from Justice Harlan's dissent. He said, in the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens.
And I find this so powerful, this story, because you have this, movement by Homer and others to test the system and say, this isn't right, and we're going to push some boundaries. They get pushed back so hard by the Supreme Court. But even within the Supreme Court, you have resistance to saying, no, this isn't right. Call it what it is. This is classism. This is creating a caste. This is wrong, and this is not what the Constitution should do. And what I think is so powerful about looking at the 14th Amendment and understanding it is sometimes the cases that don't work. Sometimes the cases where people are still fighting the good fight, even though they know they probably won't win. And we have a lot of these stories and the people that fought for the freedoms that we see under the 14th Amendment today. And so the next case that we're going to dive into is probably one of my other favorites, is Kim Wong Ark. So tell us the story about Kim Wong Ark.
So yes, this is
let me get it right.
This is 1894. It's a key case involving a Chinese American. And so Wong Kim Ark, he's born in San Francisco. Both of his parents were Chinese citizens living in the United States. And at age 21, he travels back to China to visit his parents who had recently left the United States. And so he goes to China, he tries to return back into our country, and he's denied entry on the ground that he's not a United States citizen. Now again, Wong Kim Ark, he's born in San Francisco. And so this raised the question of whether under the 14th Amendment Citizenship Clause, the fact that Wong Kim Ark was born here on American soil, whether that makes him a United States citizen, even though his parents were not United States citizens. That's the big question here. And in a 6-2 decision by Justice Horace Gray, the Supreme Court says, Wong Kim Ark, you're right. You were born on American soil. Your parents may have been Chinese citizens. When it comes to the 14th Amendment and its promise of national citizenship, it doesn't matter who your parents were. It matters where you were born. You were born on American soil, so that makes you a United States citizen. This case itself turns on that text that you have bolded there, Curry, what it means to be subject to the jurisdiction thereof. What the Supreme Court says is that in this context, what that means is whether or not you are bound to obey the laws of the United States. And so it's a really broad reading of the 14th Amendment's promise of birthright citizenship. It excludes certain people like diplomats who get diplomatic immunity, even Native Americans who get certain forms of tribal immunity. But for everyone else, no matter who your parents are, if you're born on American soil, you're generally a United States citizen.
So this is with this case, we start to see the chipping back away of the rollback of the 14th Amendment and try to say, no, this is what it says, this is what it should mean. And that brings us kind of like walking through the time period to the Indian Citizenship Act of 1924.
Yeah, and so this is a reminder that for Native Americans, it would ultimately take a law passed by Congress that grants them citizenship in the United States. So the Congress passes this law, the Indian Citizenship Act of 1924. It's passed in part in response to Native American service in World War II. And so it's where, one way to think about this is, Curry, over time, through the combination of the Constitution's text itself and laws passed by Congress, we bring more and more people into the American family and into the promise of citizenship. So this is an example of how this is done through legislation, not just through the Constitution's text.
Got it. So, Tom, when we look at these different sections of the Constitution that you broke down under the 14th Amendment, we look at equality, we look at freedom, and we look at incorporation. There's a lot to kind of dig in here and to unpack. And we see movements moving us forward and then cases that move us back. So I'm sorry, I'm jumping a little bit around here in time. But what is kind of the next significant case that you want to bring up for our students to kind of dive into and look at and examine to kind of understand, with Homer getting pulled back, with WONG art kind of moving it forward, what are some of these pushes and pulls with the constitutional law that we're seeing over time that the students should really know about, and then leads us to like understanding incorporation and the movement of the Bill of Rights to apply to the states and not just the federal government?
Yeah, so we'll get to incorporation in a moment. I think let's tie up the loose end of PLESSY first, say a little bit about women's equality, and then we'll end with incorporation. So one thing to realize is it takes a really long time for us to finally say Plessy v. Ferguson is wrong. It takes the Supreme Court over 5 decades. It's not until 1954 that the Supreme Court finally overturns Plessy v. Ferguson and says that Jim Crow segregation is unconstitutional. That's in many ways the most famous Supreme Court case of all. Brown versus Board of Education, 1954. It's Linda Brown, this 3rd grader, challenging the system of Jim Crow segregation. What does she want? She and her parents just want her to go to her local school, the one that's near her house in Topeka, Kansas, the Sumner School. But the school district says no. She says it's an all-white school and you're an African-American. Plessy v. Ferguson tells us that segregation is constitutional. Linda Brown and her parents say no. There's no way that can be consistent with the 14th Amendment's promise of equality. And whereas Plessy v. Ferguson is a 7-1 decision by the Supreme Court saying segregation is constitutional, Brown versus Board of Education over 50 years later in 1954 says no. Plessy v. Ferguson was wrong the day it was decided. We are overturning Plessy v. Ferguson. Separate but equal has no place in the context of education. School segregation itself is unconstitutional. It is unconstitutional to separate white students from African-American students. In the end, it doesn't matter whether you make those facilities equal. The very act of separation brands African-Americans with a feeling of inferiority. And here's Chief Justice Warren's powerful words. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal.
And huge, powerful case, probably the one of the most important cases for our students to learn and to understand and to examine today. So as we kind of keep continuing to move forward, do you want to talk about moving this forward towards civil rights, or do you want to jump into gender equality in the 14th Amendment?
Well, let's say a little bit. So Brown, I'll say just a couple more words about what happens after Brown, and then we could go into women's equality. So first, what Brown does in large part is it attacks the core of Jim Crow segregation, the entire Jim Crow system. It attacks it at its heart in segregated schools. But following Brown, the Supreme Court then extends the reach of Brown versus Board of Education to a variety of other settings. Then finally, Congress a decade later passes the Civil Rights Act of 1964, a sweeping civil rights law promoting equality. It passes the Voting Rights Act of 1965, which expands the right to vote to African Americans. And finally, in 1967, the Supreme Court returns again and strikes down laws banning interracial marriage in the case of Loving v. Virginia, laws that say that African Americans and white Americans can't marry.
And again, an unbelievably powerful case, an unbelievable powerful story about saying, what is our right as people to have, and how does the 14th Amendment protect this? And when we think about the 14th Amendment, we think about what it was originally written for and how future generations look and see that the 14th Amendment applies to them as well. So kind of like bring us back there for a second. What is the 14th Amendment? And what was the original intent of saying, this is what we want to do with the 14th Amendment that you told us earlier, restate that, and then how did women utilize the 14th Amendment to find gender equality, using that idea of equality and saying that's for all of us?
Yeah, so the 14th Amendment, the core case it was trying to deal with was discrimination against African Americans. Wanted to place African Americans after the Civil War, after slavery, on equal footing with white Americans. What we see from the very beginning, right after the 14th Amendment is ratified, is women's rights advocates and suffragists using the text of the 14th Amendment to say, this text, it's really broad. It doesn't say anything about race. It talks about equal protection of the laws. We want equal protection of the laws too. And so we see early challenges in the late 1800s saying women should have the right to practice law. Women should have the right to vote, making these claims under the 14th Amendment, but the Supreme Court initially says no and does not apply the 14th Amendment's promise of equality to women. But eventually, over decades upon decades upon decades of advocacy, beginning in the 1970s, the Supreme Court reverses course. You know, a key figure here in the 1970s is Ruth Bader Ginsburg. So Ruth Bader Ginsburg, before she's a justice, she's a key crusader for women's rights inside the courts, arguing many of these key 14th Amendment cases, saying that the protections the 14th Amendment gave to African Americans, they should be extended to women as well and extend the promise of equality to everyone. And finally, we see in a powerful majority opinion written by then Justice Ruth Bader Ginsburg in the VMI case in 1996, Virginia versus United States, the Supreme Court saying that Virginia needs an exceedingly persuasive justification for its policy of providing separate military training for women and for men. It concluded that an alternative school for women in this context wasn't up to snuff. It didn't really provide equal opportunities to women. And Justice Ginsburg, in powerful language, reminded us, quote, "Sex classifications may not be used as they once were to create or perpetuate the legal, social, economic inferiority of women." So here we see, Curry, over time, yes, there's a zigzag. Sometimes the 14th Amendment's promise of equality is expanded. Sometimes it's restricted. But if you're looking at the sort of the story of constitutional law over time, we could see more and more groups laying claim to the 14th Amendment's promise of equality, including women.
And I think that's unbelievably important that, you know, we had the civil rights movement last week, all the classes. And the key takeaway from those classes was it takes energy. It takes energy from the people to use it. It needs to be in the Constitution, people to call for it, get it into the Constitution, that promise of the Declaration for freedom and equality, then people to use it. And that it's not just a straight path, that there is a lot of ebb and flow, a lot of zigzag, with the overarching arc, which you just said, Tom, does bend towards people leaning on it, utilizing it, and finding it as well. And so that leads us kind of to the wrap up of the class and understanding how does the 14th Amendment and the Bill of Rights get connected to the individuals of our country and the people of our country?
Yeah, so the key text of the 14th Amendment here, this is the 14th Amendment's promise of freedom. The key text is again in section 1. It's the part that says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." Again, it's kind of legal jargony, the language is, but the idea is expansive and powerful. It's that the 14th Amendment's promise of freedom extends nationwide. For John Bingham, the author of the amendment, the key idea here is that the Bill of Rights, which when it was ratified only applied to the national government, it's now going to apply to the states as well. And so it's a vision of the Bill of Rights becoming a genuine charter of national freedom, one that applies as much to the president and Congress as it does to your governor or state legislature. The big technical term for this is the idea of incorporation. And so this is the idea that Bill of Rights protections extend not only to the national government, but also to the states. And in part, this was a response to what John Bingham and his colleagues in the Republican Party after the Civil War had learned from the decades and decades that came before. Because prior to the Civil War, prior to the 14th Amendment, when the Bill of Rights only applied to the national government, what they saw were the slaveholding states violated every core protection in the Bill of Rights. For instance, they banned abolitionist speech, abolitionist preaching. And so in part, what the Reconstruction generation is trying to accomplish with the 14th Amendment is to make sure that that doesn't happen in post-Civil War America. The big lesson of the Civil War and secession is that it's not only the national government and its abuses we should be concerned about, but also the state governments and their abuses. And so over time, what we see is the Supreme Court taking the 14th Amendment, using it to incorporate the Bill of Rights to more and more of the rights contained in the Bill of Rights over time. And so in the late 1800s, actually, the Supreme Court's pretty lousy on this. There's early challenges that early cases like the slaughterhouse cases, United States versus Cruikshank, these cases, you have challengers coming into court saying states have violated our constitutional protections. The 14th Amendment makes that unconstitutional. And the Supreme Court says, no, The Supreme Court says that's too big a change to our constitutional system. It would rebalance the power between the national government and the states too much. And so they rejected the idea of incorporation in the late 1800s. But as we get into the 20th century, we can see the Supreme Court shift. And the process is known as the idea of selective incorporation over time. And so what the Supreme Court says is we're not going to take all of the Bill of Rights all at once and saying all of it applies to the states. What we're going to do is we're going to hear a series of cases, a series of challenges, bringing free speech in, a free press, religious liberty, the Fourth Amendment's protection against unreasonable searches and seizures, case by case, right by right. The Supreme Court hears cases, hears challenges, and applies each of these protections to state abuses, to abuses by governors, to abuses by state legislatures, to abuses by police officers. And over time, what we see is right by right, the Supreme Court incorporates nearly the entire Bill of Rights. And unless you think this entire project's over, it's not. Just in the last few years, the Supreme Court has incorporated new constitutional protections. In McDonald versus City of Chicago, the Supreme Court incorporated the Second Amendment's right to keep and bear arms. In more recent cases, it incorporated the Sixth Amendment's right to a unanimous jury trial and the Eighth Amendment's right against excessive fines. And so a project that began in earnest in 1925 with the Gitlow case and the First Amendment's protection of free speech continues all the way up into recent terms just a couple of years ago. And today, nearly every Bill of Rights protection has been incorporated against the states. The only ones that have not been incorporated are the Third Amendment's right against the quartering of soldiers, the right against the right to grand jury, and the Seventh Amendment's right to a civil jury trial. Every other right in the Bill of Rights has been incorporated against the states. But finally, Curry, what we see is, and that's what this image brings up, is that these battles over the 14th Amendment, its meaning, its promise of freedom, its promise of equality, continue to this very day. If you look at the Supreme Court's docket, the Supreme Court's caseload, any given term, so many of the issues that we debate and so many of the cases that we care most about are 14th Amendment cases. A recent example is Obergefell versus Hodges, which you see here from 2015, a case that really brings in both the 14th Amendment's promise of freedom, in this case, the freedom to marry, and the 14th Amendment's promise of equality, that promise of equal protection of the laws. And as with many 14th Amendment cases, this decision wound up dividing the justices 5-4. It was a really closely split court. It involves state bans to same-sex marriage. And so we had certain same-sex couples come into court and say that these bans that we find in states throughout the nation, they violate our 14th Amendment protections of freedom and equality. In a majority opinion by Justice Anthony Kennedy, the Supreme Court says, yes, Mr. Obergefell, Jim Obergefell, you're right. These same-sex marriage bans do violate the 14th Amendment's promise of freedom and equality. And so in part, what Justice Kennedy does is he extends the right to marry that we find in Loving v. Virginia, that case that struck down interracial marriage. He then applies it in the context of same-sex marriage. And so it's a way of taking an old case, old principles, and applying it to a new context. On the other side, though, in dissent, really the lead dissent is by Chief Justice John Roberts. And what he argues is we need to take a more modest approach to the 14th Amendment. The 14th Amendment, it involves so many of the most potent and controversial issues in American life. The Supreme Court itself doesn't have clear protections, clear textual protections for same-sex couples, or even the right to same-sex marriage. What we're seeing in America over time is a grand debate over this particular issue, where actually public opinion is shifting in the direction of same-sex marriage advocates. And what the court is going to do here in Obergefell is it's going to shut down that debate. It's going to close down the democratic process. And so better for issues like this that aren't clearly dealt with in the Constitution in the view of Chief Justice Roberts, better to leave them to political processes, political debates, and the elected branches. Over time, that's going to lead to greater legitimacy for the Supreme Court and greater legitimacy for the Constitution. So you can see two very divergent visions about the 14th Amendment in this one case of Obergefell versus Hodges. Clearly a landmark case, one of the most important cases of the last 10 years, but one that divided the justices.
And Tom, that I think is the most important thing when thinking about the 14th Amendment and looking at it and understanding its history, is that we're still understanding it today. There's so many different parts to this amendment. There's such an amazing story leading up to the amendment, and then how it was used and not used in the years following to really put its meaning into practice, and how the use of it is being debated today. Whose job is it? Is this the power of the 14th Amendment, or should it be up to the states? Because as you pointed out in the first minutes of the class, the 14th Amendment still shifts the power between the national and the state government. And how are we figuring that out today? And we can see this in some of the court cases. So thank you so much for walking us through all these pieces. There is a lot in here to unpack. And students, we also understand there's a lot for you to digest. So if questions pop up after this, you can always email us, or if not, you can put them in the chat now. But thank you, Tom. This was fantastic. Thank you, students. If you don't have any questions, we'll wrap up, but thank you all very much.
Thanks, Kurt.